based on algorithms. So the kinds of bias issues we see here, for example, does the data set being used reflect the full population? And this is really important when you are dealing with issues regarding employment. You need to understand how the input creates the biased output. And one of the problems that we really face, a significant problem, is that much of the data on which the models are trained is historical data, which can perpetuate bias. If the data set is based on history, how do we prevent the same mistakes from happening repeatedly? So can the algorithm biases be avoided? You can move on, Rob. Diversity is key, and there's a great McKinsey podcast, The Ethics of Artificial Intelligence, that I think is worth a while taking a look at. But the diversity, and you know, when you think about it, when you take the step back, this is what we think about when we're doing DEIJ work, and the same is true. You have to think about it in terms of the models and the data that's driven and ultimately used to produce the AI output. Diversity of team members, the mindset, the personality diversity, data diversity, and the diversity of algorithmic models, because the more the data driven, the more that the models are trained on different types of models and information, the more robust you're going to have it. One of the problems for lawyers is you're not creating these models. You're relying on models that are being created by people who have most likely a lot more technological background in these areas than what an average attorney may have. There may be some exceptions, but this is definitely an issue that we need to think about, because we really don't know what the model is trained on. And it's very difficult then to identify what kind of issues may be affecting the output that we're getting. So let's move to the next slide. How does a user verify these questions? And that would be through data diversity and diversity of algorithmic models. And you probably should investigate the types of models you're using and find out how are they training things? Where is it coming from? Does it include the things that, for example, one thing that IP practitioners need to think about is whether it is trained on information that shouldn't be in the public domain to begin with, and how do you figure that out? You can never fully answer the questions, but the more investigation you do about the model that you're using for AI can at least help you understand how the creators of these models are approaching it. So it's something that you should do some due diligence about. Now, the thing that I think that a lot of lawyers kind of know intuitively, but let's move on, Rob, is that they need to supervise the attorneys who work for them and the non-attorneys who work for them. But knowing that intrinsically and thinking about it that way, checking their work, asking what kind of research they did, that kind of thing. We've anyone who has attorneys working for them will do that. There are two particular rules, though, that I think are worth revisiting, because these are probably some of the biggest problematic areas for lawyers who are using or allowing their attorneys to use AI, and that's rules 5.1 and 5.3. So rule 5.1 speaks specifically to partners and law firms and other managerial personnel who have the authority, they must make reasonable efforts to ensure that the firm has in effect measures giving reasonable assurances that all lawyers in the firm conform to the rules of professional conduct. We know that, but how do we administer that when we're dealing with attorneys who use AI? One of the things that I think lawyers need to do, if you're a managerial employee or partner at a law firm, is to make sure you are thinking about these issues and coming up with a firm protocol or policy that's shared with and followed by everyone in your firm who may use AI, regarding how to use AI and how to supervise maybe less seasoned attorneys on whether they're using and if they can use and how they should use AI if they're going to do that. Rule 5.1, we can advance, includes within its reach any lawyer having direct supervisory authority. So you may even have associates at a firm who are supervising even more junior associates, and these same rules apply to them. So you can think about how it works in the chain of the hierarchy of your firm. You may have paralegals doing work. You may have other non-attorneys doing work, and any number of people may be supervising them. To the extent they are using AI, they need to know what they're doing, how they're doing it, and whether it's reasonable in the way they're doing that. Go on. Let's move to the next slide. It also talks about a lawyer being responsible for another lawyer's violation of the rules if the lawyer orders or, with the knowledge of the specific conduct, ratifies the conduct. What does that mean in the context of AI? Does it merely mean that if you know they're using AI, you're going to be responsible for something that runs afoul of that's not in the best interest of a client or runs afoul of the rule? And again, you look at it in terms of, did you know and ratify it at the time the conduct was such that its consequences can be avoided, but fails to take reasonable remedial action. But how do you know that if you don't really understand AI and how it works and exactly how someone within your firm utilized it? So that's something that we need to think about. Moving on, Rule 5.3 speaks with respect to the non-lawyers employed or retained by or associated with a lawyer. It's really the same test. You need to make sure that there's a reasonable assurance that the non-lawyer's conduct is compatible with the professional obligations of the lawyer. Another thing that needs to be considered, a basic question here, is it involves AI's essential nature, and that is using AI by a non-lawyer on which a lawyer who may not be using it relies, is that practicing law without a license? If you have paralegals who are doing things and working direct with your clients, that kind of thing, that's a question you need to ask yourself when you look at AI, because there may be a lot of non-lawyers who are the ones dealing with it because they may understand it from a technological standpoint better than the lawyer itself. So this is something, and we can move through, Rob, because I don't want to waste time going through all of the rules, because these are the big takeaways are, do you have the knowledge to make it a reasonable effort to ensure that either a junior lawyer's or a non-lawyer's working for the firm's conduct is compatible with the professional obligations of the lawyer and the law firm? or the company if you're dealing with in-house counsel. All of these questions have to be asked and considered. And I don't know that there are a lot of people asking these questions and considering them. They're just practicing law like they always did and not taking into account the nuances that are inherent in AI models that could cause there to be an issue. We can move on to the next. We can go on. Confidentiality rule 1.6. So as Samsung, who should have known better, realized, it's very easy to take proprietary information and disseminate it, not thinking about it, just by the way they are instructing or asking the AI model to perform a task for them. You have to give a certain amount of information if you're going to get a response that's tailored to what it is you're trying to achieve. In doing that, you may be unintentionally putting out there that then will train on others, or actually will disclose confidential information from your clients. So you need to make sure that clients are giving informed consent. I mean, that's the general rule. A lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent. The disclosure is impliedly authorized in order to carry out the representation, or the disclosure is permitted by paragraph B. Let's move on to that. And then it goes through a lot of other situations in which you may be able to reveal confidential information. So let's go back to the prior slide though, because that is where I think that most lawyers can get hung up unintentionally. Are you giving informed consent? Does your engagement letters allow you to use AI in the practice of law for that particular client? At this point in time, I don't think there's enough out there to make us reasonably assured that AI is impliedly authorized. And so I would suggest a best practice would be to make sure you're letting clients know if you use AI, so that by signing the engagement letter, they understand that. But even more importantly, you need to be careful and train those who are using the AI, whether it's a non-lawyer or a junior lawyer or a senior lawyer, to make sure that they are engaging with the model in a way where they are not putting out there a client's confidential information, because that in and of itself is going to be a violation of the rules. Rob, we can move on through this to rule 1.6 is an extremely lengthy rule, and so I would recommend that you all read it thoroughly. And let's go to slide 38. Because another issue that we need to think about in terms of confidentiality is also the privacy issues that may be inherent in the work that you're doing for your clients. So HIPAA is the big federal statute that we need to be aware of if you're involved in anything having to do with med mal or health law. It's something that you want to be mindful of in terms of thinking about whether AI is used, to what extent it's being used, how it's being used. There are also, though, many state privacy statutes. Missouri does not have one. Illinois doesn't have an overall privacy statute, but they do have the biometric statute, and that has been interpreted in very, very strict ways and is very, very expansive. And of course, failure to follow the statutes that exist can lead to governmental enforcement actions, but also a rash of class action lawsuits that we see across the country. So California has at least two, and I think they're working on a third privacy statute. There are statutes in Colorado, Connecticut, Virginia, Washington State, and there are many that have not been enacted yet, but that are working their ways through. So to the extent that whatever issue you're dealing with may involve interstate issues, you need to be aware of all of this and make sure you're being careful about any use of AI and what kinds of information you're putting out there. There are also cybersecurity statutes, and there are foreign laws such as the GDPR in Europe, the Canadian privacy statutes, Venezuela, India. India, they actually made it part of their constitution now. And of course, it's also something inherent in electronic discovery. And that is kind of a double-edged sword. On the one hand, in electronic discovery, because of all of the different capabilities and technologies available, judges are really expecting full electronic discovery. And what is reasonable now to investigate is much more expansive than it was 10 years ago in terms of what was reasonable in terms of discovery requests. But one of the issues that judges may not yet be recognizing is, to the extent the electronic discovery, in order to get to something, is using artificial intelligence, this can be something that can get you in trouble from another rule, even though you may need to develop this electronic discovery, because the judge is saying, yeah, they're entitled to get this information. And there's not enough known yet about some of the models that are being used for electronic discovery, and whether you're going to end up in a situation of a disclosure that's beyond what would be reasonable under law. The next rule to consider is Rule 1.4 regarding client communications. And this is also a fairly long rule. So I'm not going to read the whole thing or go through that, but you can read it in the booklet. You need to think about it. It's very similar to the other rules that we've just been talking about. It's the same issues. Do you know what you're finding, what you have, how it's being used or input into an AI inquiry that someone within the firm is making? And so everything that we just talked about with respect to privacy and those implications are going to be also just as validly a question here when you're thinking about client communications. To what extent can you even avoid it? To what extent do you need to, if you're trying to do a task and write a brief or a memo or whatever it is you're trying to do on behalf of a client, to what extent do you need to include in that inquiry and instruction in the AI model to put specific information regarding your client that would otherwise be information that you are not at liberty to reveal? So these are the kinds of things that we need to think about. So let's move on through Rule 1.4. I want to say we're about at page 46. So I said it's a very long rule. So what can go wrong? Well, I'll tell you what, a lot can go wrong. And it's, I think, helpful for us to, you could go back one, and we're going to talk about what can go wrong. There have been, and you've probably seen a lot of writing and news reports on things that have gone wrong. And I'm going to focus here. I already mentioned what happened with Samsung, but that's not as, except for the wake-up call, it's not really pertinent to a lawyer practicing law. So I'm going to focus here on some of the what went wrongs just within the last year regarding attorneys, and it's happening. We'll go through 5 instances where attorneys have been sanctioned or investigated for their use of AI. So in one of the early cases about a year ago, a New York federal judge sanctioned lawyers who submitted a legal brief written by the artificial intelligence tool ChatGPT, which included citations to non-existent court cases. So there is one of the things that can go wrong in an AI project is what they call hallucinations. Based on the information that's out there, it kind of creates something that actually didn't exist, but would make sense based on things that are out there. So there was a $5,000 fine, but the 2 attorneys and their law firm who were responsible for the brief were actually ordered to notify each judge who was falsely identified as the author of a bogus case ruling about the sanctions. So imagine that. You might be citing cases from all over the country, and now you have to go tell a judge, oh, by the way, I screwed up, and here's this non-existent opinion of yours that I cited. I mean, it's just, I would not, I would definitely not want to be in that kind of a situation. Now, what was interesting here is the judge said he might not have punished them if the attorneys had come clean about using ChatGPT to find the purported cases that they cited, but they didn't do that. In fact, they kind of doubled down. And the judge said that they basically abandoned their responsibilities when they submitted the AI written brief in their clients' lawsuits against an airline, and then continued to stand by the fake opinions after judicial orders and the counsel for the other side called them into questions. The judge found not only was this a violation, but found that they had exhibited bad faith. And then for future reference for all lawyers, the judge said you need to, in researching and drafting court submissions, good lawyers appropriately obtain assistance from junior lawyers, law students, contract lawyers, encyclopedias, databases such as Westlaw and Nexus and Lexis, excuse me. And you need to utilize those, that there's nothing inherently wrong with using AI, but you can't let the standards go. And so, a lot of us would sit back and say, well, we would never have done that. We're going to read those cases. We're not going to rely on AI. But apparently a lot of people don't. And in reading some of these rulings, apparently even not using AI, a lot of people don't actually look at the cases they think they're citing, and often will miscite a case and what it stands for. Another New York lawyer also faced discipline after an AI chat box invented case citations. At last, they were investigating her. She was facing possible discipline for non-existent cases that were created by artificial intelligence. And it was viewed as marking AI's latest disruption for attorneys and courts, learning to navigate the emerging technology. And the court found that the conduct fell well below the basic obligations of counsel. That was a 3-judge panel for the Manhattan-based Court of Appeals. So the judges are not amused when this happens. In another case, a Colorado lawyer submitted a motion with fictitious case laws that was sourced from ChatGPT. He failed to verify the sources before submitting the motion. And when the lawyer discovered the fabricated case law, he failed to disclose the issue to the court or withdraw the motion. Had he done that, he also may not have been sanctioned. But when the judge inquired about the case law, the lawyer falsely blamed a legal intern. Later, the lawyer admitted in an affidavit that he had used ChatGPT to draft the motion, and he was subsequently suspended for a year and 1 day. And so the judge was not amused. In a case that you also may have seen more recently, Michael Cohen's lawyer had filed a motion in November for early termination of his supervised release, and he cited 3 cases that supported the argument for granting early determination. Another lawyer later appeared for him and notified the court that they were unable to verify those 3 citations. And the court found it notable the government didn't acknowledge that the fictitious cases were fictitious. So the judge was chiding both sides, the lawyers who cited the fictitious cases, but also the governmental lawyers who were on the other side who didn't realize it. So they apparently hadn't gone looking to read those cases. So the court, the Southern District of New York, issued an order to show cause, directing the originating lawyer to provide copies of the cited decisions. And they were considering sanctions when they weren't able to prove these cases existed. So the last thing that I wanted to draw your attention to and what could go wrong is one case, and it's an egregious case, and it came out of Missouri and was looked at by the Missouri Court of Appeals. And this case applies to non-attorney litigants. Here it was a pro se person who had used ChatGPT or had hired, he later claimed he had hired an attorney in California to write a brief for him. But the fact that the judge was so harsh in this case, I think it bears mention, particularly if you are using non-lawyers at the firm to help with anything involving AI. So in this case, an O'Fallon, Missouri man who used artificial intelligence to generate almost 24 fake citations was ordered to pay $10,000 in sanction for wasting the time of his courtroom opponents. The court was very frustrated and said the use of artificial intelligence forcing opposing counsel to, quote, expend more resources than necessary to decipher the record warrants sanctions for filing a frivolous appeal. The court also said they were particularly concerned that appellants submitted a brief in which the overwhelming majority of the citations are not only inaccurate, but entirely fictitious. Out of 24 case sites, only 2 were genuine. So what had happened there is opposing counsel doing a good job of pulling all of the cases, couldn't find any of the cases and tried to get them and asked for them and had to go through all different manner and means to try to figure out if these were legitimate cases. And ultimately the judge said that this is not something could be countenanced, is a flagrant violation of the duties of candor appellate owes. Now, interestingly enough, there have been a lot of commentators over this case, including former Missouri Supreme Court Chief Justice Mike Wolf, who said this case could actually result in new court rules guiding AI, whether by a lawyer or a non-lawyer litigant. So the stakes can actually be very high, and there are more and more of these situations happening every day. Rob, we can move on. So talking about risk allocation in all of these different issues, who decides what's ethical? Who determines the standard of care? Who is responsible for AI when it goes awry? We don't have a lot of guidance. As I mentioned earlier, there are some rules being generated within companies, within law firms. There are at least two, not Missouri or Illinois, but there are at least two state bars that have developed some AI guidelines. There are many other legal groups and bar associations looking into the issue. But in looking at this, one big thing to think about is who is responsible for AI gone wrong. So we can advance the slide. When an AI system error falls below the standard of care, first of all, there's going to be the question of what is the standard of care. Think about all of the people that could be involved and whose work can be scrutinized. The lawyer, for sure. The AI developer, perhaps. The AI system trainer, possibly. A consultant who recommended the system, maybe not, if that was the only thing they did. All of the above, possibly. And is anyone in that chain, as I mentioned earlier, practicing law without a license when they're deciding to use this? So the big question then becomes, and we can advance, should you or should you not use AI in the practice of law? And I will tell you that many law firms and some courts have said, no, you can't use it. Others are allowing it, some very studiously and judiciously, and others aren't. They're just looking into it, seeing what they can do. So questions to consider before you implement any kind of AI use or rules in your office is what type to implement. Is AI okay? Or are you willing to look at the generative AI where now you have a computer thinking for you, not just researching for you? What does client training look like? You definitely should have training for anyone involved, whether that is the client, whether it's the attorneys or the non-attorneys who work at the firm. You need to make sure you set up an easily understood audit trail. So of communications within the project or the client, or within the law firm so that you can easily understand it. You also need to think about what kind of oversight. Do you need a data scientist at the law firm? Or is there a lawyer with the requisite skills? Do you need an analytics director, an advanced training educator? You also have to think about fairness and how is the AI training set examined for responsible AI, and you may need a consultant for that. So what I want to leave you with today are what I think are some of the best practices as you look at these questions. If ultimately you decide you're going to use AI, don't do it blindly. Engage in your due diligence. There's no debate that ChatGPT and other similar models are prone to hallucinations in legal research. They have a tendency to fabricate case law for the very proposition that the attorney is seeking. And if generative AI is used for research and briefing purposes, a lawyer's ethical duties of competence and diligence obligate them to double check the existence and accuracy of the citations, as well as the propositions for which they stand for. You can't cite to these cases without doing your due diligence or you will get in trouble. The responsibility, I think, as I mentioned before, is not one-sided. If you are an opposing counsel, you need to look at all of the cases that are cited so that you could figure out whether these are real cases. That's an obligation you have for your client also. I would say the second principle for best practices would be to check the court rules. Many judges now have issued standing orders regarding the use of generative AI when drafting court filings. As I said, at least 2 courts prohibit the use of generative AI. Others require lawyers to disclose its use and certify that the AI work product was diligently reviewed by a human for accuracy and applicability. And before submitting any court filings, lawyers obviously should check the local rules as to whether their judge has issued any AI-specific standing orders and to make sure that they abide by those requirements. If best practice number 3, don't double down. If the court or opposing counsel draws attention to an allegedly fabricated case, either produce the case or admit that it was improperly relied on through generative AI and withdraw the brief, or ask the court to let you remove that citation. Lawyers who submit the court filings with fabricated content needs to be honest with the court as soon as they discover it. The speed at which you do this may help reduce the likelihood and the severity of sanctions. Number 4, don't blame subordinates. As I said at the beginning when we started talking about things, don't blame it on an intern or a paralegal or someone else who's not a lawyer. The managerial lawyers at the firm can easily be held accountable for this, and it's also just bad form to do that. And finally, and I mentioned this earlier, you really need to have, if you're using it, you need to have policies, really well thought through and well drafted policies, and everyone in your firm who would be possibly engaged in use of AI needs to be trained on this. So those are my thoughts on this subject. It's a fun topic area. There's a lot that can go wrong, but there's a lot of good also. Rob, you can advance. So I've also put some books and educational opportunities and some resources that you may want to take a look at that can help you learn more about AI, and I wish you well if to the extent you decide to use it.
Mary Ann, thank you so much. One thing that dawned on me as you were going through these examples, most of the examples of the uses of AI were involved in litigation.
Yes.
And I'm curious of your thoughts as to whether there's more of an opportunity to use AI in a transactional practice, such as drafting a contract or a provision to a contract. I have very little personal experience, but I can tell you I had a conversation with a lawyer who said, "Have you ever used ChatGPT?" I said, "No." And in like 3.1 seconds, he dictated into his phone in ChatGPT to spit out a consumer arbitration clause in Missouri, and it was about a half page. And I looked at it, and I got to tell you, it was pretty good. It had the legal disclosure requirement by our statute. So, do you think we have more of an opportunity in the transaction arena than in litigation?
I actually think that both in litigation and transactional work, including intellectual property, there is an opportunity, a good opportunity to do it. And what we kind of were focused on today is how you can go afoul of the rules of ethics. The same rules, though, would apply because you may be getting something. You would need to, for example, double check, is this actually consistent with what that the disclaimer that needed to be included. You need to double check the work. I think that's probably the biggest thing. It's kind of like Law 101 for a new associate. Make sure anything that you find in Westlaw or Lexis. You're checking, does it actually say what you think it says? Does it stand for your proposition? So I think that, yeah, for sure, you can use it well transactionally. I think one of the reasons a lot of what we're seeing though is litigation is because that stuff is manifesting itself more quickly. You won't necessarily see issues relating to corporate documents until something goes wrong in a relationship and then someone sues over a clause that may have been generated by AI or was done without someone knowing there was AI and now it caused a problem for them, or information has been revealed that wasn't confidential. So the big thing you need to do is your due diligence to understand what you're getting, make sure that it's accurate. But yeah, if you want to, AI can be great at helping you certainly get out of the box with a task that otherwise you're just spinning your wheels trying to get off the ground. So I wouldn't say don't use it. I'm just saying be very careful and be mindful if you are going to use it, how you're going to use it, and that you're aware of the implications of using it.
Good. Well, Mary Ann, thank you so much for your presentation, and I do recommend for the attendees to take a good look at your materials. They are in depth, providing the ethical rules, but also some of the issues involved, and then the resources were terrific. So, Mary Ann, thank you so
You're
much.
welcome. Good luck, everyone who's using it.
Thanks. We're going to take about 6-minute break, and we'll start back up again with our next program. Thank you.
Johnson, I'm currently.
All right, Cardina, let me just a quick intro for everyone. Just to let everyone know that there will be an evaluation that is in the materials, and I think Kelly will be emailing that to you as well. In addition, the program that we'll be doing on June 26th will be emailed shortly as well. This next program on retaliation disputes in the workplace, Cardina Johnson, a terrific member of the USA&M mediation group, and is also Deputy General Counsel of the Illinois Education Association. And Cardina, thank you for bringing this topic to us. I know it's been a hot topic for some time, and we appreciate your experience.
Thank you so much, Rob. Thank you for that introduction. Yes, as Rob mentioned, I work for Illinois Education Association as the Deputy General Counsel. I'm also on the panel for USA&M. And our legal department at IEA represents more than about 130,000 members across the state of Illinois in their labor and employment matters. I would just like to say good morning again. If you wanted to log into the session, retaliation disputes in the workplace, what's protected, what's not, and how to avoid them, you were successful. Look at you achieving your goals already this morning. So the substantive information on the slides come from the EEOC website, for which the specific link will be provided at the end of this presentation. Please be aware that I am battling a bit of a cough. So if you suddenly see that I have muted, that may be the reason. That, or maybe I talked myself into some kind of euphoric state and I time traveled to the weekend already. So, okay, let's go ahead and get started. Let's see. So the overview of this presentation is we're basically going to be talking about 5 main parts. First, we're going to talk about retaliation generally. We will define terms like protected activity and material adverse action. We will also discuss causation and evidence standards that will be used in retaliation cases. Additionally, we will review the concept of ADA interference, what remedies are available, and then we'll review some US Supreme Court cases. And finally, consider some best employer practices for making a workplace ideally free of retaliation. So, what is retaliation? We have to start with a definition. So most all of our labor and employment related laws have some sort of retaliation definition and provision. Each of the EEO laws prohibits retaliation and related conduct. So the laws that I'm referencing are Title VII of the Civil Rights Act of 1964, the Age Discrimination in Employment Act, the ADEA, and then Title V of the Americans with Disability Act, ADA, and Section 501 of the Rehabilitation Act, which is the Equal Pay Act, EPA, and Title II of the Genetic Information Non-Discrimination Act, also known as GINA. So state laws across the country contain similar provisions. And as a labor and employment attorney, I would be remiss in not also mentioning the National Labor Relations Act, NLRB, which has a retaliation provision as well. Defining retaliation calls for, us to review some key terms. Retaliation is when an employer takes material adverse action against an employee for exercising their statutorily protected right to engage in protected activity. So materially adverse actions are those actions taken by an employer that have a tendency to dissuade a reasonable worker from making or supporting a charge of discrimination. The EEOC, Equal Employment Opportunity Commission, and for the National Labor Relations Board and similar state entities that investigate claims of retaliation as a result of a discrimination case being filed are the basic enforcers. And they enforce the complaints of retaliation. So can retaliation occur prior to an actual protected activity occurring? Well, if I could hear you, I would ask someone, but I can't, so I'll say, why, yes, it can. If someone feels that they cannot even first complain about discrimination without being subjected to an adverse employer response, then that employee has experienced retaliation. And that's a bit confusing, so let me just give an example. So, for example, an employer could not have a policy that expressly states, if you complain about your employment conditions that relate to the holidays that the company does not observe, then you will be terminated or docked days. So that would be a problematic statement that you would not want your employer client to say, and it would be a smoking gun for a plaintiff client. So let's see. Now, let's looking at the next slide. We want to know, what is a prima facie case, for retaliation? And retaliation cases are basically center around the prima facie case, as you would guess. And there are 3 elements, and they're pretty straightforward, as you can see. It's basically the employee engaged in prior protected activity. The employer took a materially adverse action against the employee because of that activity. And then there was a causal connection between the protected activity and the adverse employment action, which is basically the but-for cause standard. So what type of activity is protected from retaliation is what we want to consider now. And the definition of protected activity is key to that. Protected activity is divided into 2 categories under the law. And those 2 categories, first is, begins with participation, which is the clause that bars retaliation related to the employee participating in an EEOC investigation. Basically, the long and short of this is that it deals with complaints and investigations involving the government or relevant state agencies. But then there's the second clause, the opposing or opposition clause, which refers to activities occurring in-house, meaning these complaints are made, within the employer's four walls. And it will explain, and basically I'll explain that more in detail later, but I just wanted you to have this general concept as we're moving forward. So then what part of the complaint process is protected from retaliation? Well, the protected actions in the process can take on many forms, but the basic way of thinking of it is that most any part of the complaint process from the beginning to the end is protected, whether it's something that's considered participation in complaining or even opposing discrimination. So participation refers to any activity involving an EEOC investigation. That is activities such as filing a complaint. What else could you do? Just other things like participating in ways that do not require the claim to have any merit or timeliness, or even, they don't even have to be true, honestly. Even silly and baseless complaints are protected from retaliation when you're talking about this type. But I will say that there is a split between the circuits as to whether the complaint must be done in good faith. And we'll look at a Supreme Court case that talks about that in a bit. But some jurisdictions say that a lack of good faith is not protected under the acts. Other jurisdictions might find it acceptable, if the employee's claim is just basically untrue. So given the point of the participation clause is to protect the EEOC process, the focus is not really on whether the claims are true or not. So opposing unlawful conduct is different than participating in an investigation. It's basically the entire complaint process that's being focused on. Opposition is what happens in-house. So unlike participation, for example, opposition to receive protection, there definitely must be some kind of legal merit there. Okay, so consider like a claimant, for example. If a claimant must have a reasonable belief that unlawful activity occurred, and they don't have to have a reasonable belief, in the sense that if they have a good faith idea that something has happened under the law, that's good enough. So it's kind of a bit confusing how the sort of standard is. And so I'm going to have a little pop quiz to make sure that I'm explaining it well. So this requires the employees to somewhat know what is unlawful and what isn't. And let's look at slide 7. Let's see. Oops. Okay. So the entire complaint process is protected from retaliation. Complaint processes begins with the unlawful discriminatory act of the employer and covers all actions taken through the conclusion of the complaint. Examples, which may be helpful to tie everything in, of protected actions in the retaliation complaint process can be all across the board. So as you look on your screen, you see that there's taking part in an internal or external investigation of employment discrimination. Maybe there's someone who's resisting sexual advances or intervening to protect others who have these advances. There's just a wide array of things that can be covered in the complaint process. So another example is if an employee refuses to follow a directive that would result in discrimination. For example, if a middle supervisor was told by a department director to discipline someone because of their Germanic nationality, or even, like I said, resisting unwelcome sexual advances qualify. So it's just a full gamut of things that I think a lot of people maybe would not think about as being retaliation initially. So what does it mean to participate? I just want to recap to make sure that was clear that in an attempt to give a little more energy to the virtual process, here's a 2-question pop quiz. So, okay, so open, it'll be open notes. And so that's no problem. And it's going to be easy because I'm going to give you the answer. So it shouldn't be a problem. Participation is when an employee has filed a complaint of retaliation based on having participated in the discrimination process in the ways I just referenced. Remember that even nonsensical complaints are protected from retaliation. So what does it mean to oppose alleged unlawful conduct? The second question on your pop quiz, what does it mean to oppose unlawful conduct? This is when the employee opposes unlawful conduct that the employer has taken. In response, the employer cannot punish the employee for communicating opposition. The employee has to have a reasonable, good faith belief that unlawful discrimination occurred in order to file a meritorious complaint. Okay, so here are some examples of opposing conduct. You will see examples on the slide. You will see that there's a concept that's written there called passive resistance. And it refers to when an employee joins in corroborating or, acquiescing to a coworker's complaint. An employee also cannot be retaliated against for requesting a reasonable accommodation or talking to coworkers about the employer's discriminatory practices. Basically, in short, it's an unlawful action for employers to retaliate against employees for participating in the discrimination process or internally opposing adverse actions taken by the employer. Okay, so great work. Everyone passed the quiz with flying colors. Okay, so then let's move on to a different concept, and that is the compensation discussions. Let's pivot all together and look at that. So in general, an employer cannot pay comparable employees differently based on their gender, their sexual orientation, their nationality, etc. It's important to note, though, that there are different variables to consider that might account for a deviation from this rule, like the demographic composition or like the bargain pay scales maybe that a union might have. So taking adverse action due to being aware that employees are discussing compensation may implicate a number of different federal laws under EEOC enforced laws. When an employee communicates to management or coworkers a complaint or asks about, like compensation or otherwise discusses what their rate of pay, the communication may consist of protected opposition under the EEO laws, making employer retaliation actionable based upon the facts of the given case. And I want to add too that talking to coworkers to gather information or evidence in support of a potential EEO claim is protected opposition, provided that the manner of the opposition is reasonable. An employer that may try to create a code of conduct in a handbook, for example, stating, in a handbook that discussions of pay is barred here, would need to be advised that such a code would not override the law, of course. So an employer should not bar these conversations, no matter the code or conduct or preference. Then going to the next slide, there is more discussion that I wanted to share with you on the compensation discussions. There are also federal protections for discussions related to compensation. For example, under the Executive Order 13665, and that was issued in 2014, that was enforced by the US Department of Labor's Office of Federal Contract Compliance Programs. Federal contractors and subcontractors are prohibited from discharging or otherwise discriminating in any way against employees or applicants who inquire about, who discuss, or even disclose their compensation. And this also includes applicants as well. You can look into more information on that if you happen to have a specialty related to federal employees, which can be found on the website, the DOL.gov website. Moreover, the National Labor Relations Act protects non-supervisory employees who are covered by that law from employer retaliation when they discuss their wages or working conditions with their colleagues as part of a concerted activity, even if there is no union or other formal organization involved in the effort. And I want to skip this slide because I think it was a duplicate. Going to the next one. Okay, and so then we want to know who is protected from retaliation. And basically all employees covered under the Civil Rights Act and its correlating state laws and the other federal laws previously mentioned, are at play when you talk about who's protected. Both public and private sector employers with 15 or more employees are prohibited from retaliating. Protection from retaliation also applies to labor unions as well. So the prohibition against retaliation includes applicants, full-time, part-time, temporary, and former employees also. Your client should be aware that it is unlawful to refuse to promote an employee who has applied for a higher position due to the filing of a discrimination complaint when they were an applicant. And we'll look at a case like that in a little bit. Prohibition against retaliation applies irrespective of citizenship and status. So your client should definitely also know that they cannot threaten or be threatened with deportation recommendations if an employee files a complaint. But the good news for those of you who represent employers is that a looming or existing retaliation claim cannot be used as a shield of protection against the employer if they're issuing discipline for misconduct or downgrading an employee for legitimately, like poor performance that won't impede or stop the opportunity to have the individual be disciplined as needed. So I will discuss this concept more on an upcoming slide. So when is an employer action serious enough to be retaliation? So you will recall that retaliation must be materially adverse. Again, materially adverse actions are those actions taken by an employer that has a tendency to dissuade a reasonable worker from making or supporting a charge of discrimination. So then, some of the examples include, denying a promotion, refusing to hire an applicant, suspending an employee, or terminating employment are all straightforward examples of serious enough actions to qualify as a materially adverse action. Excuse me. More examples of materially adverse actions are on your screen now. If you were in person, I would like to ask if any of those stand out as ones that you didn't necessarily think of as serious enough. But I'm not in person, so I won't ask you that, but I'm wondering your thoughts. One that stands out to me is disparaging persons to others or in the social media. Turning to the next one, there are some NLRB examples of material adverse actions as well. So with NLRB issues, typically they deal with traditional labor unions. So the kinds of adverse actions that are going to be examples are more frequently ones that concern employees who are laborers. And so you will see some of those labor type examples. Those are on your screen. And now let's consider, when is the employer's action serious enough to be retaliation again? Let's look a little bit more into that. And to determine when the employer's actions are serious enough to be retaliation, what will happen is the fact finder would have to analyze the actions taken and consider the facts. So you'll see examples of serious enough retaliation actions from case law that have been deemed materially adverse. One that stands out to me, as you look on your screen, is changing a parent's already established work schedule. And I'm thinking that's likely to be one that would create childcare issues for the employee. That would be serious enough. Then turning to slide that talks about what is not materially adverse. We got to consider petty slights. If there are some basic insults or rude comments that are being made, they do not rise to the level of retaliation. You might also notice a lack of good manners or, things that aren't courteous from your colleagues. But a superior that fails to address an individual properly or simply ignores that individual just doesn't seem to rise to that level. They may make, an employee feel unwelcome, but they may not qualify as materially adverse actions. The same goes for minor annoyances to the employee. Trivial punishments like transferring an employee from an office to a cubicle, according to case law, do not rise to the level of being materially adverse. But I know that some of us may have nice corner offices, and this might be a big deal if it personally affected us. Nevertheless, this is the kind of case that the 11th Circuit heard. And in that particular case, it was held that the transfer of an HR professional to a job on the floor of a chicken processing plant was a significant change in duties and allowed the case to move forward. So that is something to consider factually. And the guidance from the EEOC on the retaliation notes that a U.S. Supreme Court, in which the nation's top court determined that transferring a worker to a, quote, harder, dirtier job within the same pay grade and suspending her without pay for more than a month, even though the pay was later reimbursed, is a materially adverse action. So on one hand, the courts have concluded that a temporary transfer from an office to a cubicle was not a materially adverse action because such a move was a trivial punishment or petty slight, not likely to prevent an employee from engaging in protected activity. But similarly, the Third Circuit rejected an employee's gender discrimination claim, finding that the denial of the worker's request to take a software training course wasn't an adverse employment action. So I think the answer to this really is, it just depends. Now let's consider third parties. Employees targeted with third-party retaliation are protected under the Title VII of the Federal Civil Rights Act. So what is third-party retaliation, though? In third-party retaliation claims, an employer doesn't retaliate against the person who actually submitted a claim, a complaint. So it's not the filer, it's not the person who came to HR and made their complaint, but instead it's against someone else in their, what you would call their zone of influence in response to the employee's protected activity. So employees targeted with third-party retaliation are protected under the, like I said, the same Civil Rights Act that I just mentioned. But sometimes an employer takes a materially adverse action against an employee who engaged in protected activity by harming a third party who is closely related to or associated with the complaining employee. So that could be even a friend or even a family member. The Supreme Court in McGee versus Healthcare Service, which we will look at in a bit in more detail, held that the plaintiff could proceed with a Title VII retaliation claim based on allegations that after his wife filed an EEOC charge against her employer, the plaintiff was fired from his job with a company that held a contract with his wife's employer. So the court explained that this is, quote, obvious that a reasonable worker might be dissuaded from engaging in protected activity if she knew that her fiance would be fired. Similarly, if an employer punishes an employee for engaging in protected activity, by canceling like a vendor or contract with the employee's husband, even though he was employed by a contractor, not the employer, it would dissuade a reasonable worker from engaging in protected activity, is how the court saw it. And so although there is no, quote, fixed class of relationships for which third parties' reprisals are unlawful, firing a close family member will almost always meet the standard, and inflicting a milder reprisal on a mere acquaintance will almost never do it. So we get a little bit of insight about how courts look at these third-party cases. Where there is actionable third-party retaliation, both the employee who engaged in the protected activity and the third party who is subjected to the materially adverse action may state a claim. The third party may bring a claim even if he or she does not engage in the protected activity, and even if he or she has never been employed by the defendant's employer. So excuse me. So who must prove retaliation? The burden is on the employee to prove that retaliation has occurred by proving the elements of the prima facie case that I talked about before, which again is the employee engaged in protected activity. The employer took a materially adverse action, and a but-for causal standard that I previously mentioned, in which a causal connection must exist. So a materially adverse action does not violate the EEO laws unless there is a causal connection between the action and the protected activity. The retaliatory animus doesn't necessarily have to be held by the employer's official representative who took the materially adverse action. It could just be their representative. So rather, it could be an employer may be liable if one of its agents, motivated by discriminatory or retaliatory animus, intentionally and cause the official to take the action. So that's something to consider as well. In private sector and state and local government retaliation cases under the statutes that the EEOC enforces, the causation standard is a little bit different, and that these employees would need to show the discrimination was a, quote, motivating factor, end quote. So it requires the evidence to show that, but for a retaliatory motive, the employer would not have taken the adverse action as set forth by the Supreme Court in the University of Texas Southwest Medical Center versus Nassar, which is another case that we will also look at. Then we want to get into the standard of proof for retaliation. And so, as you can see on the screen, the standard of proof for retaliation is preponderance of the evidence. And in order for the employee to prevail in demonstrating a violation of the evidence, the evidence must show that, there is more likely than not a chance that retaliation has occurred and that the retaliation was at least a contributing factor for the adverse action. It is not the employer's burden, though. They don't have to disprove the claim. It's not a burden for them. Now, different types of evidence, either alone or in combination, can be used to determine if the above causation standard has been met. So, in other words, different pieces of evidence, like if you consider them together and put them all together, may allow an inference that the materially adverse action was retaliatory. The evidence I'm referring to may include, for example, suspicious timing of the action taken, like after the protected activity, soon after, excuse me, verbal or written statements, comparative evidence. For instance, that when I say comparative evidence, I'm talking about a situation where there's a similarly situated employee who is treated differently, and the evidence that tends to prove that the employer's reason offered for the adverse action was false, or any other evidence which, when viewed collectively, may permit an inference of retaliatory intent on behalf of the employer. So I think I didn't complete my thought when I was talking about suspicious timing. I mentioned actions that happened right after protected activity of the employee. So the causal link between the adverse action and the protected activity is often established by evidence that the adverse action occurred shortly after the plaintiff engaged in protective activity. So nevertheless, I want to emphasize that this type of timing is not necessary to establish a causal link, but that's the typical causal link that you will see. So even when the gap in time between the protected activity and the adverse action is long, other evidence of retaliatory motive may establish the causal link. As a practical matter, an opportunity to engage in a retaliatory act may not arise right away. So just as a matter of practicality, it may be a year or two that something else comes up where there's an opportunity where that individual finally applies for a job, that is a promotion, and then that's when something happens. Some other evidence to consider is oral or written statements that are made by the individuals. Those statements recommending or approving the challenged adverse action may reveal retaliatory intent by expressing retaliatory animus or by revealing inconsistencies, predeterminations, or other indications that the reasons given for the adverse actions are false. Such statements may have been made to the employee or to others. So that's something to consider as well. And then an example of comparative evidence is another type of evidence, I should say, that we should consider, and an inference that the adverse action was motivated by retaliation could also be supported by evidence that the employer treated more favorably a similarly situated employee who had not engaged in protected activity. So where a disciplinary action was taken for alleged retaliatory reasons, evidence of selective enforcement, just meaning the infraction regularly goes on and it goes on, it's undisciplined, they do it all, other people do it all the time in that particular workplace, or that another employee who committed the same infraction or issue was not disciplined or is not, disciplined as severely as the person that's, making the complaint. Those all could be sufficient to infer that there's some sort of retaliatory motive. Excuse me. Without evidence of new performance problems, a retaliatory motive might be inferred where an employee had higher performance reviews prior to engaging in protected activity. So that's something to watch out for, and you probably want to look at an individual's particular evaluations to see what they say. And it does look suspicious if this person was always doing great in a particular area, and then, there's years and years of, with excellent marks for a particular employee after being evaluated, and then all of a sudden there is this bad mark right after they filed a complaint of discrimination. So let's also consider the infamous inconsistent or shifting explanations. I think most all of us have been, maybe if you do any type of litigation, in a situation where you've prepared your witness and you thought that you knew everything that they were going to say, and lo and behold, there's this new explanation that pops out that you did not expect. So if the employer changes its stated reason for the alleged adverse action over time or in different settings, for example, reason stated to employee in termination meeting is a different reason that's stated by the employer, maybe at the EEOC investigation. When you have those situations, pretext may be inferred from those facts. So as a matter of law, there can be that inference made. The inference of discrimination that can be drawn from the inconsistencies, however, can be overcome to the extent that the inconsistencies are somewhat insignificant or can be credibly explained by the employer, like when additional information is discovered later. Sometimes you have that information that you find and it really comes and helps and saves the day. The final evidentiary claim that I'd like to discuss is the claim that the employer's explanation itself was pretextual. So there may have been evidence that the employer's justification for the challenged action is not believable and that the explanation is a pretext to hide unlawful retaliation. And this is the slide that I had been talking about. I didn't advance it as I spoke of it. So let's continue. Defenses against retaliation. So, all right, how about we turn to the defenses and consider those? So an employer may offer a legitimate non-retaliatory reason for an alleged adverse action. Examples of non-retaliatory reasons could include, look, there was poor performance of the employee, that the employee has an inadequate qualification list and, for a particular promotion that they are seeking, or the applicant's qualifications, application, or interview performance were inferior to the individual who was ultimately selected. So that's a clear defense. Even if protected activity and a materially adverse action occurred, evidence of any of the following facts alone or in combination may be credited by the fact finder in a given case, and as a result lead to the conclusion that the action was not retaliation for the protected activity under the applicable causation standard. First, retaliation cannot be shown without establishing that the employer, either the decision maker or someone who influenced the decision maker, knew that the prior protected activity existed. So without knowledge, there can be no retaliatory intent, right? Because, if they don't know, the complaint has to go. They just don't know. So there's no causal connection in those instances. An employer could argue a legitimate non-retaliatory reason for the challenged action. And in examples of non-retaliatory reasons include, as we talked about before, and as you see on the screen, the poor performance is one, inadequate qualifications for positions are sought. There are more insubordination, unexcused absences. We have reduction in force, or other downsizing. Just in sum, though, the employer does not have the burden to disprove retaliation. The employer may have evidence supporting its explanation for the challenged action. And then those comparative evidence, and then that comparative evidence will reveal the treatment of the similarly situated individuals who did not engage in protected activity or supporting documentation that tends to say that retaliation didn't happen, and or even witnesses. So there are several things that the employer has when it comes to defenses. Let's consider two hypotheticals that can be found on the EEOC website, and they are listed as examples 21 and 22. Example 21 is an employee alleges that his former private sector employer gave him a negative job reference because he had filed an EEOC discrimination claim after being terminated. So the employer produces evidence that it usually provides information about previous employees' job performance, and that they're just basically doing what they always do, and that its negative statements to the prospective employer were honest assessments of the former employee's job performance. Consider your thoughts on whether this is retaliation from your perspective. Well, the commission guides that unless it can be concluded that the negative reference was because of the discrimination claim, retaliation would not be found. And then another example that I just talked about was example 22. And it talks about action not motivated by retaliation of a plaintiff. So the office manager of a service company believed her non-selection for various managerial positions was due to sex discrimination. She thought, because I'm female, I didn't get this job. And she posted on an online social media platform, "Anyone know a good EEO lawyer? Need one now." So then management saw this and shared it with human resources. Plaintiff was subsequently discharged and alleged it was retaliatory. However, the evidence showed that termination was due to plaintiff's extensive unauthorized use of overtime and her repeated violations of company financial procedures, which were enforced to other employees and for which the plaintiff had been previously issued written discipline. So she's already got written discipline in her record. Drum roll as to if you consider this to be retaliation that can be proved. There's my drum roll. Even though management was aware of plaintiff's protected activity, her intention to take action on a potential EEO claim, plaintiff cannot prove retaliatory discharge. So again, that would be a lot better if we could do that in person, but I think we love the convenience of this. So let's keep going. So you can see the other examples on this slide as well that relate to defenses against retaliation. In short, though the employer does not have the burden to disprove retaliation, the employer may have evidence supporting its explanation for the challenged action, such as comparative evidence revealing like treatment of similarly situated individuals who do not engage in protected activity, or supporting documentary evidence and/or witness testimony. So just wanted to wrap that up and move on to our next topic, which is interference with ADA rights. So in addition to retaliation, the ADA prohibits interference with the exercise or enjoyment of ADA rights, or with the assistance of another in exercising and enjoying those rights. The scope of the interference provision is broader than the anti-retaliation provision that we have been talking about. So the ADA protects any individual who is subject to coercion, threats, intimidation, or interference with respect to ADA rights. As with ADA retaliation, an applicant or employee need not establish that he or she is an individual with a disability or qualified in order to prove interference under the ADA. So that's not necessary as you might think it would be. Interference could include a denial of reasonable accommodation itself. So that in and of itself would be enough. So some examples of interference. You will see examples of interference on this slide, like intimidating an employee who is requesting, to take leave is another example. I don't believe there are any surprises with these examples that you see. They're pretty straightforward. Now, here are some other examples, like subjecting an employee to unwarranted discipline. There's demotion, other adverse treatment, where they have assisted a coworker with paperwork and requesting reasonable accommodation. Similar to retaliation, the interference provision does not apply to any and all conduct or statements that individuals find intimidating. So in other words, it just can't be petty slights or insults. It has to be more than that. In the EEOC's view, it only prohibits conduct that is reasonably likely to interfere with the exercise or enjoyment of ADA rights. Also, like retaliation, a threat does not have to be carried out to be unlawful. So you can make the threat and then the employer doesn't have to carry it out, but it still could be a problem for that employer.
Ardina, we have about 3-4 minutes. Just want to give you a heads up.
Thank you so much. Then when we talk about remedies, the EEOC has the authority to seek temporary injunctive relief before a final disposition of a charge. When a preliminary investigation indicates that perhaps a situation can benefit from prompt judicial action, and that it's necessary to carry out the purposes of Title VII, the ADA, and GINA, which all incorporate the provision for this type of relief. So just to be aware that those remedies are available. And then there is obviously the compensatory damages that are being referenced there as well. So that is something to be aware of, that back pay as well as front pay could be provided. In addition, some other remedies could be punitive damages, but please note that the punitive damages are not available for the government, employees, and there's also equitable reliefs to consider, like, what you traditionally would look at, which would be reinstatement or maybe a change in policy, or basically an agreement that, hey, we won't do that anymore, that type of thing. Which brings us to our US Supreme Court cases. I had a few of those listed there, and I think this may be a duplicate, so I'll skip that one. But I'll just pick out maybe one of them, just so that we get a feel for what the Supreme Court has been doing over the years as it relates to retaliation. So I think what we'll look at is, let's see, I'd like to look at. Let's look at Casten. I think that one is referenced on the next slide. Let's see, oops. Well, I think that in the interest of time, it'd be more important for me to just talk about the good employer practices as I rethink of it. So let me get into that so that we have this last couple minutes in case there are questions. So nothing will be etched in stone, of course, nothing will be the savior as to how you can prevent retaliation cases, but some very straightforward pointers include: maintain a written plain language anti-retaliation policy. I know that a lot of employers have sexual harassment type of complaints and similar ones, but make sure that retaliation is specifically included, even though the law may not necessarily require that, as it does for other things. And then make sure there's a clear internal reporting process in that policy, ideally. Another good practice is to have manager training. Managers need to know when retaliation is happening and how it happens. And another thought is that spotting issues early can really help. So in considering spotting issues, one thing about retaliation is it's typically stemming from a situation where an individual has already filed a discrimination claim. So therefore, if you're trying to look out for retaliation, that should be an easy marker to say, this is an issue. Maybe we need to analyze this, and maybe we need to talk to the right people to make sure there's no retaliation that's going on. And then requiring managers to explain a reasoning prior to taking an adverse action. And, sometimes when you get together and have thought partners who can think about ways to avoid matters, it can be very helpful instead of doing things maybe when an individual is angry and is acting in a vacuum. And finally, on this other slide about practices, there is a clear avenue. I'm sorry, that was a duplicate that I wanted to skip. So spotting issues early, I already talked about that. And then requiring managers to explain their reasoning, we already talked about that. And so the last thing is clear documentation. That's always important, as we know as attorneys. And some information on how to file a claim or to obtain more information on EEO, and the resources that I previously told you about, that you can find things that I've talked about in these concepts and these documents.
Cardina, thank you. A ton of material, and we probably should have had 2 hours for this. That was my fault.
Thank you.
It really is great material. We do see a number of these issues come up in mediating employment cases, and I think this is great information for us. Folks, we're going to take 5 minutes. We'll switch the PowerPoints and we'll get started. One thing I will mention, Kelly will be emailing an evaluation to you. Also, on page 4 of your material is the certificate of attendance for today. What you need from that for MOBAR reporting purposes is the course number, and it's on page 4. I'll give it to you now, though. 743578, and that's the course number for this morning's program. So we'll stand adjourned for about 5 minutes. And again, Cardina, thank you.
Thank you, Rob.
Before we get started with our last part of the program, first want to thank Kelly Spiller of our office, who has really been the force behind gathering the materials, following up with our speakers, putting together all of the flyers that you all have received. She will be emailing to everyone an evaluation form. We appreciate your comments, and the most important thing I would be interested in are future topics that you're interested in for future programs, as well as if you have any suggested speakers. That would be well received. The other thing is she will also email a copy of this upcoming flyer for the June 28 program, which is just a terrific lineup, and we know that you'll appreciate the breadth of the information we're providing and the variety of speakers who will be presenting. Without further ado, Steve Schwartz, a partner at Brown & James, very experienced both in litigation and writes a column in the Missouri Lawyers Weekly on legal ethical issues. We're thrilled that he's a member of our mediator panel and senior arbitrator panel at USA&M. And Steve, without further ado, thank you.
Thank you. Morning, everybody. I think I'm the only thing standing between you and lunch, so hopefully we can get through this and fulfill the CLE requirement. I have to speak for an hour, so I'll speak very slowly in case I don't have enough material. But I welcome questions as we go along. And Rob, how do they ask the questions?
They can post a question in the chat, and then I'll monitor the chat, Steve, and then let you know.
Okay. Yeah, so feel free to ask questions as we go along. I think it's my goal is to make this interesting for you. So if you tell me if you have questions, it helps me gear my discussion to what you're interested in hearing about. So my topic today is avoiding legal malpractice claims. I've been defending lawyers for over 30 years in malpractice and ethics claims. Also represent other non-medical professionals, accountants, insurance brokers, title agents, etc. And so I've spoken on this before for USA&M as well. As Rob mentioned, I do write a monthly column for Lawyers Weekly on malpractice avoidance. And that is geared, to practice tips, really. It's not a legal discussion. It's a discussion about practical ways to avoid getting sued or having someone make a claim against you. And that is what this discussion is going to be today. And a lot of things I'm going to say today are also covered in the monthly columns. And so if you go back and if you subscribe to Lawyers Weekly, you can go back and read any of those. They're all online at the Lawyers Weekly website. So some of the things I'm going to talk about today, I'm going to talk about, here are some of the common claims that we see on a regular basis. A lot of claims are timing mistakes, missing statutes of limitations or other deadlines. Timing mistakes often fall into categories of failing to diary, failing to recognize potential claims, failure to follow up, and I'm going to get into more detail on all of this later. Another common thing that we see that causes malpractice complaints are just failure to set expectations and having clients who have expectations different from what the lawyer's expecting. and I'll talk about that. A lot of complaints and more ethics complaints of malpractice is failure to communicate with the client, failure to respond to client requests for information, etc. Then there's also the category of claims that just come from difficult clients. So I'm going to talk a little bit about how to deal with difficult clients. Other common claims include claims that arise out of lawyers handling matters outside their wheelhouse, things they're not really, don't have experience in, but they take on anyway. So I'm going to talk about that. We've had claims where lawyers failed to advise their client about insurance, and they end up handling matters that should have been covered by insurance and not letting the client know they should turn in their claim to insurance. I'm going to talk a little bit about covering up mistakes. That's a mistake. And so I'll be talking about that. A lot of claims come from just inadequate discovery of facts. The FDCPA claims are just really very common. It's not really malpractice. It's more of it's a federal claim against collection lawyers. And so most collection lawyers are familiar with those laws, but we still get claims. A lot of claims are caused when the client is sued for fees, and then they file a counterclaim. That's extremely common. And then I'll talk a little bit about suits by non-clients and just claims that you just can't avoid no matter what you do. Most of the lawyers I represent I represent them on cases where they've been sued for the first time. And quite a few lawyers will go through their whole career and be sued once. And I always tell people that it's the statistics show that the longer you're in practice, the more likely it is that you're going to get sued, just because you've had more clients, you've had more instances, more opportunities for a client to sue you. And so it's upsetting when you get sued, but it really is part of the practice and has to be expected at somewhere along the line. I really like representing lawyers. I feel like it is a service to the profession, and most people think lawyers are really bad clients, but it's the opposite. Most of my clients, once they're comfortable with what I'm doing, tend to just let me run the show and don't interfere much at all. So some tips on things you can do to try to avoid being sued. Set expectations early with your client. Enter into a retainer agreement. It's extremely important. Certainly if you're representing a client on a contingency, you have to, under the ethics rules, have a written agreement. But whether you're representing someone by the hour or on a contingency or a flat fee or whatever fee arrangement you have, it's best to have a retainer agreement. And one thing you want to do is define the scope of your representation in that agreement. Unsophisticated clients and even sophisticated clients may think you're their lawyer for one thing, and so you should be looking out for a lot of other things. And that's may not be your expectation. Just because you represent a client on some matter, you're not their general counsel necessarily. So it's really important to find in your retainer agreement what the scope of your representation is going to be. And then at the same time, in the retainer agreement, you want to set forth the client's responsibilities, which includes payment terms, being forthright with facts, to information that should be provided to you, and that sort of thing. The client has responsibilities as well. Consider a mediation clause in your retainer agreement. We're going to plug for USA&M, but it really is helpful to have that clause that requires client to seek mediation before they file a lawsuit. In the end, it's probably best for the client as well. And of course, in your retainer agreement, you're going to be clear on what the fee terms are going to be, the payment terms, the timing of payment, the timing of invoicing, the timing of payment, what happens if they don't pay, and that sort of thing. So again, this is all about setting expectations, making sure you and the client are on the same page. So the next thing I want to talk about is communication. And I've highlighted this. Most of the cases we have could have been avoided with one email or letter confirming something. And when you don't have that, then it maybe you're word against the clients, and it's a lot harder to defend if you have that. And quite often, it could be the end of the claim. It could be avoid the claim completely. So you can't put every communication in writing, but things to try to put in writing is confirm in writing all strategic decisions or major events in a case, and deadlines and trial dates. So just really the most important things in the case, but specifically just strategic decisions, it's best to put them in writing, because lawyers are entitled to make strategy decisions, but with consultation of the client. And if you've consulted with your client and you confirm that in writing, that's going to help in your defense of any claim. You should always notify your client in writing if you're going to be giving up any of their rights or any of their claims. So if you're going to dismiss a claim, if you're going to waive a jury, if you're going to agree to choose a magistrate over a federal judge, for example, which you can do, in Eastern District, they quite often ask you to. I think the Western District Federal Court in Missouri, they ask you to do that. And there's nothing wrong with doing it, but you do want to notify your client that they have a choice between an Article III judge who's appointed for life or a magistrate who's appointed for a term. And it's a constitutional right, so it's something that you should definitely put in writing. Settlement is a key thing that should be in writing. You should notify your client in writing of any settlement demands and any offers, and you should always confirm any authority that you're given by the client in writing. Again, all of this is just to avoid an argument about it later. Then, like I said earlier, one of the major causes of malpractice is missed deadlines. And so the first thing to do about that is make sure you know the statute of limitations. And you should always verify all the facts that may help determine the statute of limitations. And you should not rely on client's memory or statement of facts if you can verify those facts with independent information. For example, if a client comes in and says, I've been a victim of malpractice. I last saw my doctor last year at this time. You really want to get the medical records and confirm when was the last time the client saw the doctor, because that often triggers the statute of limitations. And sometimes people get confused on dates. And we've had situations where a client says, I last saw the doctor a year ago, but it turned out it was a year and 11 months ago. And if you don't check, then you might miss the deadline. Diaries are extremely important. Everything has to be diaried, and you need to have a good system for diarying. It's best to have a backup system. So it's best to have, if you rely on a computer, you may also want a paper backup. It's whatever your preference is, but the backup is also human backup. So if you're relying on your assistant to diary deadlines, that's fine, but you ought to be double checking, or you ought to have someone else in your firm, if there's other people in your firm backing you up, reminding you of deadlines and looking at the calendar. Procrastination.
Go ahead.
Hi, where are you? That's a great background. I'm sitting in my back deck.
Could we ask everyone to mute their microphones? Thank you.
Procrastination is often the cause of missed deadlines. We've had a number of cases where, for whatever reason, the lawyer just didn't get on the case. It may have been a case they were not really excited about handling, and they put it on the back burner and they missed the statute of limitations. So it's just important that get a case in. I mean, in Missouri, you have 5 years on most claims. And you may not get the case until 4.5 years have passed, but normally you have plenty of time to file a lawsuit. And if you just put it on the back burner and forget about it, that's the worst thing you can do. Another thing that causes missed deadlines is not considering other claims that you may need to file, or at least warn your client about the deadline. So, for example, if a client hires you to handle a work comp claim, are you also going to be responsible for bringing any tort claim against a non-employer, a third party who may have responsibility? That's something that if you're not going to take that responsibility, then that should be in your retainer agreement. It should be highlighted for the client, the statute of limitations. They should be told about the statute of limitations if they're going to need to hire another lawyer to handle that tort claim. You have to always remember second injury fund claims if you're handling work comp. And then think about all the defendants that may, all the potential defendants that you may need to sue. Again, you can miss the deadline if you've not sued everybody that the client has a claim against. Or if you don't want to file that claim, or the client doesn't want to sue someone, or you don't think it's valid, again, put in writing, we're not suing this potential defendant because we don't think we have a claim against them, or whatever reason, so that down the road, the client doesn't come in and say, why didn't you sue this other person? There's claims against government entities often have different statutes of limitations. The Federal Tort Claims Act has different statute of limitations. There's notice requirements for municipalities as well. And so those are things you always have to think about. We've had cases where Missouri lawyer takes on a claim that needs to be filed in Illinois, and they're not as familiar with the Illinois statute of limitations. So again, you have to be aware of what you're doing and make sure you've thought about when did the cause of action accrue, when does the statute run, which statute of limitations am I going to consider? Missouri has a borrowing statute. So even if you're filing a lawsuit in Missouri, the statute of limitations from another state might apply if that's where the cause of action accrued. And so you really have to consider all of that. And then even if, I said before, like if you're going to not take on a claim, you're not planning on filing a third party claim, and you're only going to handle the work comp claim as an example, you still need to notify the client of the statute of limitations. Or if you don't know if you're not analyzing the statute of limitations, you're not sure when it's going to run, notify them that you don't know, they need to get someone else's advice about it. Personal injury claims are typically, you can figure out when the statute starts to run. That's not always true with economic loss claims. It can be more complicated. So you want to, if you want to either be convinced of when it runs, or if you're not sure, notify the client that need to get other opinions about it. This kind of dovetails into failing to discover facts. A timing mistake can occur because you haven't done enough investigation to know when the cause of action accrued. Same example of when the client is confused about when they last saw the doctor, that sort of thing. You want to really have some verification before you determine for sure when the statute of limitations started to run. Next one. So we've had a number of cases where a case was settled and then the client sued. And there are a number of ways this can arise. There are situations where a client claims after the fact that you settled without authority. And that's why it's critical to put your authority in writing before you settle the case. We have other cases where the client says the lawyer didn't advise me completely about how much what my case was valued at, what my case was worth. And so it's helpful to document your evaluation and recommendations regarding settlement. So you put in writing what you told the client about the value of the case and the reasons that you believe that's the value of the case. And summarize for the client the reasons why the client may or may not want to settle. And then also critically make sure that the client knows the state of your knowledge or lack thereof. For example, if you decide to go to early mediation or have an early settlement before you've done discovery or before you've completed discovery, it's important to put in writing to the client, we may not know all the facts. And there's more information we might learn, but there may be reasons why the client wants to settle early. They may need the money. They may not want to have to go through the litigation. They may not want to have their deposition taken, etc. And so there's reasons to settle early, but you do need to notify the client in writing. There are facts that we don't know. And so you have to consider that down the road, we might find more information. We've seen situations where the defendant says to the plaintiff's lawyer, we're offering you this now, but if you file a lawsuit, it's off the table. We're not going to offer anything. Okay, you may or may not believe them, but if they use that tactic, you need to notify the client where you are with that. They may want to go ahead and take whatever the offer is rather than risk losing the opportunity to settle for that amount of money. Again, you'd want to put in writing, here are the things we might find out if we pursue the lawsuit. Here's what might come out in discovery. But if the client wants to settle early because they don't want to risk it, it certainly, it may be the right decision. They just have to make that decision with all the knowledge.
Steve, on that last topic, occasionally cases come before us for mediation in the personal injury context where they are either pre-suit or early on in suit. They've agreed to mediate, or perhaps there was an order to mediate. And we learn that the plaintiff is still treating. And it's always incumbent upon the plaintiff's counsel, obviously, to share with that plaintiff at that point. They don't know how much they don't know about the condition, whether there might be a future surgical recommendation, etc. And your idea to put into writing a client's wish to settle early for whatever the reason is, to provide that disclaimer that the case may have higher value depending on what happens into the future. I think that's a great idea.
Yes, and most settlement agreements say that the plaintiff is agreeing to settle without knowing what may happen in the future. That's typically language like that. So certainly that needs to be pointed out, that they can't come back later if things change.
Mm-hmm.
But again, there could be good reasons to settle anyway. As I mentioned before, FDCPA claims are a very common claim that we see. That might be an exception to the rule that the lawyers may only get sued one time in their career, just because the most minor slip up or mistake in filing a collection action could result in a claim. They don't typically have a very high value, but it's still a claim and it has to be defended. I talked about retainer agreements at the beginning of your representation. It's also important that when you end a representation that you send a closing letter or some email or something to notify the client that you're no longer representing them, that you've completed your representation. We've seen claims where the lawyer thinks they've closed the file, didn't memorialize that, and the client thinks they're still representing them, and they try to hold the lawyer responsible for something that happens after the fact that the lawyer didn't deal with. And so again, it's best to, when you're done with the case, write to the client, notify them what your file retention policy is going to be, because the ethics rules require that you retain files for a certain period of time, or notify the client that if they want their file back, they can have the file back instead of you retaining it, and close out the file so that there's no confusion with the client as to whether you're still their lawyer. And also, it's important, if you decline representation, client comes to you and wants to hire you to file a case and you decline, you should warn about the statute of limitations in writing. Or again, if you're not sure, you haven't had a chance to analyze when the statute started to run, tell them that, and so that they know they need to get a new lawyer to look at that as soon as possible. So as I mentioned before, one cause of legal malpractice is just having a difficult client. And a lot of times you can see this coming a mile away, where you just have clients that from the beginning are very demanding. They're taking up all your time, and my lights just went out. And hold on, I had to stand up because I have an automatic switch that will go back on if I make some motion. There we go.
There you go.
So you can often spot the clients that are going to be difficult, and those clients often file legal malpractice cases. So consider cutting your losses early if the client is just too difficult to deal with. If you're going to withdraw from a case, make sure you do it in a way that's not going to prejudice the client's rights. So you can't withdraw on the eve of trial. You can't withdraw if there's deadlines that the client's not going to be able to meet. But you can still withdraw if you do it in a way that the client has time to find new counsel.
Steve, do you find that when the client is meeting with you and you learn that you would be the second, third, or potentially fourth or fifth lawyer representing that client, that's the red flag for these kinds of clients?
So I put on here, don't be the third lawyer on the case. It's not, there's nothing wrong with a client being unhappy with a lawyer and hiring a second lawyer. But when the client has had two strikeouts with a lawyer, either the lawyer fired the client or the client fired the lawyer, that's a red flag. Why are you now the third one coming in? And why is the client having trouble keeping a lawyer? You definitely would want to investigate that very much in depth before you agree to represent that client. And I've seen this wasn't a legal malpractice case, but there was a case I was involved in where another lawyer from Florida was hired. He was the third or fourth lawyer on the case. And the client just didn't have any money to pay him. He must have given him a retainer. But we were in federal court here, and the judge wouldn't let him out. The judge said, you had a chance to evaluate your client's finances, to evaluate whether you were going to get paid. You're stuck. And the judge was making the lawyer fly up here multiple times from Florida on his own dime, multiple requests to withdraw. The client even fired the lawyer, wrote a letter saying, I'm firing you. The judge still would not let him out of the case. He just said, look, you bought into this. You could have decided well in advance that this person wasn't going to be able to pay you, but you decided to take the case, or you're stuck. I've never seen anything like that before, but it's a lesson learned for that lawyer and for other people watching that. You just don't want to get in that situation. So ways to avoid problem clients: carefully evaluate the case, don't be the third lawyer, protect yourself with a retainer agreement and a deposit to apply to fees. Quite often you might ask for the deposit to apply to your last invoice. So you have that protection. If they don't pay along the way, you have that deposit. And just bottom line, you have to be prepared to walk away. You don't stick with the client if you know it's going to be a really difficult situation. It's going to hurt you more. It's going to help the client. And it's just a malpractice claim waiting to happen, because if that client is unhappy in the end, they're going to sue. So stay in your wheelhouse. That was one of my columns. Many claims just come from lawyers handling matters outside their expertise or experience. And young lawyers who are on their own, or even not on their own, want to take everything that comes in the door because they want to build a practice, and that's understandable. But it may not be worth it, because if you make a mistake, you're going to be in trouble. But you can protect yourself by getting help from someone more experienced, or someone who has experience in that area, associate with another lawyer, and then you could learn that area of law with that help and still handle the case, or refer the matter out. But there's so many claims arise because a lawyer takes a case they just don't know how to handle. Now, what do you do when you make a mistake? The first rule is don't try to cover it up. You should report your mistake to the client promptly. If it's an irretrievable mistake, in other words, you missed a deadline and you can't get an extension or relief from that deadline, then you may have a conflict of interest in continuing to represent the client, because now you have a different interest in the case than the client does. So you may have to withdraw at that point. So again, if you cover up the mistake, that exasperates the case. It could lead to punitive damages, and it could lead to more damage, actual damages, and lead to punitive damages if the client can prove that you were intentionally covering things up. I usually tell people, don't admit that you committed legal malpractice. You can admit that there's a mistake made, but I've seen lawyers who say, I made a mistake, you can sue me, I have insurance. That's not the best way to go. You can tell them, I can't represent you anymore, I made a mistake. But just like you wouldn't want someone to get out of their car after a car accident and say, it's all my fault, I'm really sorry. Hopefully they don't say that if it wasn't their fault. But it's fine to say, look, I missed this deadline. But if you admit that you committed legal malpractice, you're admitting that you were negligent and it caused damages. And that's not always true. There may not be any damages as a result. The client may not have had a great case to begin with, or maybe they were going to lose the case if you're defending it. Maybe they're going to lose it anyway. So it doesn't mean they have a claim. It means you made a mistake, and that's as far as it goes. Always report any mistake, even if you don't think it's that significant. You should report it to your insurance carrier timely. If you don't, you may not be covered. And contrary to conventional wisdom, for malpractice insurance carriers, they don't they're not normally going to hold it against you because you report something that doesn't turn into a lawsuit, doesn't turn into a claim. They encourage those reports, and they just mark it down as it's a report. It's an incident that could be a claim. And if it doesn't turn into the insurance company paying out money, either in defense costs or indemnity, then normally they're not going to hold it against you, and they're not going to raise your rates. If you have a broker that you're working with for your insurance, the best thing to do is talk to them about that issue, because they'll know the answer to those questions. So as I mentioned earlier, one cause of malpractice is the failure to tell your client to consider insurance if they're getting sued. And a lot of times people assume, well, you're getting sued for breach of contract, you're getting sued for fraud, that's not going to be covered by insurance. It's not necessarily true. They could still have a right to a defense. If they have D&O insurance, for example, that covers a lot of different things. If you're representing a officer of a company or a company itself, and they have D&O insurance, you'd be surprised what that can cover. I've defended D&O claims, patent claims, misrepresentation, theft of money, all kinds of things, which the insurance company may not have paid in the end, but they're still defending it. And so if you defend the case, don't consider insurance and charge the client a bunch of money, and that could have all been paid by the insurance company, they're going to be upset with you. And I actually took on a case, it was a copyright case, where the client was in California. They hired a lawyer in California to defend a preliminary injunction matter, not thinking that they wouldn't have any insurance for copyright. And they paid their lawyer, who lost the preliminary injunction hearing, about $500,000. And then they turned it into their insurance company. And the insurance company said, we're defending this. You actually have coverage for copyright infringement. And so the client was very unhappy with that prior lawyer. So when in doubt, if there's any possibility there could be coverage, have the client report it to the insurance company. The worst thing that can happen is the insurance company says, we don't have responsibility for this, but at least you've given the client the advice they should report it. Every malpractice carrier will tell you that one of the biggest causes of a legal malpractice claim is when the client gets sued for fees, and then they file a counterclaim. So it may be the client may not be paying you because they're unhappy, or they may not be paying you because they don't have the money, and you may not, and it may be they don't have the money and they're unhappy, or but one way to find out the hard way if they're unhappy is to sue them and then have them file a counterclaim against you. So one is you want to avoid a fee dispute if at all possible by, again, having a very strong retainer agreement, taking a deposit for fees, and firing the client if they don't pay you after a sufficient period of time. But if you do have a situation where you feel like you have to sue the client to collect your fee, just think about the risks and benefits of that. How much money is it worth? If it draws a malpractice claim, how much is your deductible, your insurance deductible? How much is that going to cost you just for the defense cost part of the claim? Because most of the time the deductible is going to apply to the defense costs. So you may want to give it a second thought. You know, if you have a high deductible insurance policy and the client owes you less than that deductible, you may want to rethink whether it's worth suing them.
Steve, we had a question in the chat.
Yes.
So Judge Mark Siegel asked, what kind of claims might there be against a mediator? Not that there would ever be a claim against his honor, but you know, some of the things that you've talked about so far, you know, technically, procedurally, I've heard of cases where mediators didn't actually communicate demands or offers. But your concept of staying in your wheelhouse, I could see applying where someone represented themselves as, you know, an expert in whatever the subject matter area is, and yet when they get into it as a mediator, they had none. But do you have any thoughts about what types of claim might apply?
Well, if I'm not mistaken, I think the statute protects the mediator. The Missouri statute protects the mediator, and then usually the mediation agreement protects the mediator. So I think the claims are probably pretty rare. I don't know if you've had any at USA&M.
It's been very rare, and to my knowledge, in the past 13 plus years, there was one claim filed in Illinois, and it was dismissed on a motion to dismiss.
So I don't think the judge has anything to worry about, but I think it's just extremely rare. And I think most lawyers know you can't sue the mediator, and you sign a contract saying you're not going to sue the mediator. I don't think mediators are expected to have in-depth legal knowledge on every case they're mediating. It's up to the lawyers to educate the mediator on what the law is. And so I don't think that would be an issue if the mediator is handling a case that they don't have experience with. In my mind, it's important to have a mediator that knows how to mediate rather than a mediator that knows the subject matter. Hope that answers your question.
Great, thank you.
Someone I noticed in the chat, someone asked if the mediation clauses are enforceable in a retainer agreement. I think so. If you have an arbitration clause in your retainer agreement, that's another story, because that's a situation where the client is waiving rights, and they would probably have to have independent counsel look at that. But a mediation clause is really, it's just an agreement to talk about settlement for the most part before they file suit, and so I believe it would be enforceable. Most judges, I think, would prefer that you try to settle the case before you pursue it anyway. So I think they would, and most of the cases, quite often the judge is going to order mediation anyway. So let me talk a little bit about, got a few minutes left, about suits by non-clients. So they fall into a couple different categories. One is malicious prosecution and abusive process, and the other is suits by third-party beneficiaries, shareholders and partners of a corporation, that sort of thing. Malicious prosecution, abusive process, we get them pretty often, but they almost never win. And you would be hard-pressed to find those cases in the books where the client won that, or not the client, the opponent who's suing the lawyer. Because in Missouri, to sue a lawyer for malicious prosecution, you basically have to establish that the lawyer knew the client was lying about the facts, or the lawyer knew, and that the lawyer knew the client had an ulterior motive for filing the lawsuit other than to collect on a claim, or that the lawyer had his own ulterior motive, his or her own ulterior motive, some personal vendetta against the defendant in the underlying case. The test is, I don't have time to go into it all now, but the test is completely different from the situation where the litigant is being sued, because lawyers have to be protected. They have a right to bring claims, even weak claims, as long as they're not frivolous claims. And so even if it turns out the claim had no merit, then the issue is, did the lawyer know that, have actual knowledge of that, and did the lawyer file it for a reason other than to try to get money for the client and to collect a fee? And it's extremely hard and very rare to prove that, although people try on a regular basis. The other type of claim is claims by shareholders or partners of a partnership or LLC trying to sue the lawyer for the entity. That's banned. You can't do that, but people try. And then the more common situation is claims by third-party beneficiaries, a beneficiary of a trust or of a will. And there is a carve out in the law. The Donahue case from the Missouri Supreme Court dealt with a situation where a lawyer was alleged to be negligent in preparing some type of testamentary transfer, a will or something like that. And the negligence caused the intended beneficiaries to lose out. And in that situation, which is still fairly rare, the Supreme Court said that that beneficiary, the intended beneficiary, can sue because they're the only, the client's deceased and the third-party beneficiary is the only person who can sue. But basically the test is they have to be an intended beneficiary of the attorney-client relationship. And that's going to be sometimes hard to prove. In that case, the Supreme Court set up a 6-factor test, a balancing test that the court has to consider to decide whether or not that third party can sue. It's a test that lawyers, there's no way a lawyer could look at that in advance and know who they have responsibility to. And so the best advice in that situation is do the right thing for the client you know you have. You can't think about who else might sue me, because if you do that, you just can't do your job. So you just have to do the right thing for the client, for that person who hired you, even though down the road someone could claim that they have a right to sue for that. In the end, you can't protect yourself from every claim. You can do everything right and still get sued, and it happens a lot. So you just have to, in the end, be prepared that it could happen, and make sure you have insurance, and make sure you have the right amount, the right kind of insurance. So one mistake that I see clients make is they buy a very small policy, and sole practitioners sometimes do this. They buy a small policy, $100,000 policy that depletes with defense costs. That's essentially nothing, because you basically bought a defense and nothing more. And if the lawyer defends you, but you still lose the case, and you have no coverage. And the 100,000 may not be enough to try the case. So that's a bad idea. You just have to, my recommendation would buy at least 500,000, and probably more, but you should rely on your broker to help you determine what you need. I wish the insurance companies wouldn't sell those $100,000 policies, because it puts us in a situation we have no choice but to just try to sell the case as quickly as possible, because we're burning the policy as we go along, and we have to sell it early, and that's not really good for anybody. And the other thing in buying an insurance policy is consider whether the insurance company is going to choose your lawyer or you're going to choose your lawyer. And sometimes they charge you more to have your right to choose counsel, but you also have a right to ask the carrier who's on your panel, who's on the, who are the potential lawyers that could defend me. It's something you probably want to know, because you may not be happy with their choice unless you know what it is in advance. So it's about 12:05. We have time for questions. Any more questions if anybody has any? I'm looking at the chat to see if there's any more.
Steve, one thing
Yeah.
I wonder if you could go into, and that is, in your experience, what is the interplay when a legal malpractice claim is raised and a possible parallel ethics claim before the Office of Chief Disciplinary Counsel?
So
Sometimes there are both.
right. So we run into that. We try to ask the disciplinary counsel to stay their investigation until we resolve the malpractice claim, because we don't want the client to be using the ethics claim as a kind of a way of getting discovery or putting the lawyer in a bad position when they're trying to defend the malpractice claim. The ethics counsel sometimes will do that, sometimes they won't, but we usually request it because it's I won't say it's unfair, but it makes it more difficult to be defending them both at the same time. If you win the malpractice claim, you're probably going to be okay on the ethics claim, not necessarily vice versa. But the lawsuit's going to reveal discovery, and there's going to be a lot more information available to the ethics counsel if they wait till the malpractice claim is resolved.
The thing is there a common theme on the legal malpractice side? I'm thinking like the ethics area, the folks who talk to us about avoiding ethics issues. Many of those surfaced around failure to communicate with the client.
Right.
And do you find that the legal malpractice claims start with, as a foundation, of failure to communicate with the client?
The ethics claims often arise, like you said, the lawyer's not responding to the client. That may or may not be malpractice. It's just bad. It's unethical and it's bad form because you have a duty to communicate and to stay in touch with the client, as the client has a duty to stay in touch with you. But it's not necessarily going to result in any damage. So it's not necessarily going to be a malpractice claim. When I talk about failing to communicate, in this discussion, I was talking more in terms of failing to communicate the important information that the client needs to know so that they don't turn around later and see you and say, you didn't tell me that. But I see ethics claims, we see a lot of them relate to financial issues, fee disputes, mishandling of escrow money, and failing to be responsive to the client. There are situations where a lawyer makes a mistake and there's an ethics complaint. But just because you commit malpractice doesn't mean that we're unethical. Making a mistake is not necessarily an ethics violation. It's a mistake. And everyone makes mistakes at some point, along the way. So they're not the same and they're treated differently.
Are you seeing a trend, Steve, in more cases in a particular area? Is it folks missing statutes, or what is there? Are you seeing more of one type of area?
When you say trend, I don't see any difference from what it was 10, 20, 30 years ago, but the things I talked about are the most common: missing deadlines, settlement issues, and just failing to set the right expectations and have the client thinking that something's going to happen, which is not going to happen. So, the client thinks that they're going to win the case because you told them they were going to win. That's if you said it wrong, they are going to be unhappy and they might file suit. We also do get a fair number of pro se lawsuits against lawyers, and those tend to be more of the failure to communicate. The client just didn't understand what was happening, and they don't have a lawyer to file the lawsuit for them because they probably don't have a very good claim.
One other question that came out of the chat: is there a risk to counsel involved in a pre-suit mediation for not having adequate discovery? And I think this would apply both plaintiff side and defense side.
Yeah, so that is a risk. But that's why you have to memorialize to the client where you stand. And so it could be a situation where it could be a divorce case where the client wants to settle early, they want to get it over with. That's completely understandable, but you'd have to put in writing, I haven't had a chance to do a full investigation of your spouse's assets, so you might be giving up something that you're entitled to. Same with a personal injury case. We may not have all the medical records. We haven't had a chance to interview all the witnesses, whatever it is. You just have to put that in writing and let the client know what might come up down the road, and they have to make that decision. I don't want to spend time on this. If I can get X amount of money, I'm happy, I'm done. But as long as you write that down and they agree to it, and you confirm that they agree to it, then should be okay.
Great. Great. I don't see any other questions in the chat. And Steve, thank you for sharing both your experience in this area and practical ideas, because you're in the trenches representing folks every day, and we appreciate you sharing those with us. I want to thank also everyone for attending, your support for Legal Services of Eastern Missouri, Land of Lincoln Legal Services, and the St. Louis Survivors Legal Support. Proceeds that you have advanced for this seminar are going to those organizations that are so worthy and important in our area. We look forward to seeing you on June 28, and you'll be hearing from Kelly more about that and also the evaluation form. Thanks everyone for attending. Have a great day.